Okay, pleased to meet you again. So, how do you consider the libertarian argument? You may well burst with what? Western philosophy, so Platon, the concept or justice of Aristotle. It would drive us an immense trace of history. How did John Locke conceive the property right concept? So actually very perplexing if we endeavor on a philosophical contemplation. Often we have other moderate form of argument. You see the public and private dichotomy could possibly see some convergence in education or other public institution would boost the naked nature of a discussion. How do you consider John Dewey in that stream of souls? How do you consider the importance of just Mill's on liberty? It's actually the concept of liberty, as we reviewed in the last class, is never limited even in a classic viewpoint. So that could espouse many elements and positive, I suppose, to progress the society. And in that line of thought, we also consider in this class the concept of a regulatory taking. I mentioned the police power and the public calls to regulate the private interest. However, in that case, we would face the constitutional challenges about taking and just compensation. It is one important element that the modern constitutionalism espouses. The taking would be simple in our basic notion and epistemology. However, in some cases, we may encounter some typical paradigm about a public regulation. You see in the case titled Dolan versus City of Tigard, Keller versus City of New London. Actually, the eminent domain would not be exercised in this case, which means the state eventually did not take the property ownership. They merely restrict the use and require statute mandate the owners to provide some space for public use and public purpose. Do you see it kind of a taking? Actually, on behalf of the owners, it will incur the interest of a property, incur the loss of priority interest. However, in no physical sense, the takings would not occur. So do you see it deserves a compensation? So the condemnation of property would not explain all the cases in the context of compensation. We will take a brief look at that issue in the cases, and also one other issue about working standard in early years of last century. The case name would be Lochner versus New York. As I mentioned, in this case, the Supreme Court reviewed the constitutionality of a New York State statute passed in 1897 that prohibited employment in a bakery for more than 60 hours a week or 10 hours a day. Lochner, an employer, repeatedly violated this statute. He was convicted, and the highest court in New York affirmed the conviction. He then appealed his conviction to U.S. Supreme Court, arguing that the labor statute denied him property without due process of law. Then what does he mean by property in this case? Of course, profits made from the labor workers he employed in his bakery. Further, he maintained the state regulation of working hours interfere with his freedom contract, alleged protected under the Constitution. A 5-member majority of court agreed with Lochner and struck down the New York labor law. So, actually, the concept about a sanctity of property or freedom contract is foundational in the preserve of American constitutionalism. So the common law lawyers, interestingly, perceive the civil code of civil law tradition as quasi-constitution. So the kind of issue is actually very important and determines the basic profile of a state affair in modern democracy. They consider the civil code, for example, a Napoleonic code. We Korean people also have a civil code. So, what is this? That should be a quasi-constitutional. Although we now manage the system from the congressional authority. So the idea is interesting in distinction, which of course would be in scholarly or intellectual attitude. Not actually the practical consequence would not diverge between two traditions, I see. Lochner is a classic example of the influence of laissez-faire economic thought on judicial philosophy. The court treated workers and bosses as if they were both equally free to make choices regarding how long they wanted to work and under what conditions. In this sense, this case is often cited as an example of legal formalism. The school of jurisprudence that ignores the impact of economic and social inequalities on the freedom of individuals or groups. The dissenting opinion in this case, however, sharply dispute the validity of laissez-faire assumptions and the social Darwinian implications for the role of government in protecting the public interest. So Justice Peckham delivered the opinion of court. The question whether this act is valid as a labor law, pure and simple, may be dismissed in a few words. There is no reasonable ground for interfering with the liberty of person or the right of free contract by determining the hours of labor in the occupation of a baker. And there is no contention the bakers as a class are not equal in intelligence and capacity to men in other trades or manual occupations, or that they are not able to assert their rights and care for themselves without the protecting arm of the state, interfering with their independence of judgment and of action. They are in no sense words of the state. Viewed in the light of purely labor law, with no reference whatsoever to the question of errors, we think that a law like the one before us involves neither the safety, the morals, nor the welfare of the public, and that the interest of the public is not in the slightest degree affected by such an act. It's actually excessive working hours worse in terms of a labor standard, and it may incur the problem of public health. It is a question of which of two powers or rights shall prevail: the power of state to legislate, or the right of the individual to liberty of person and freedom of contract. The mere assertion that the subject relates, though, but in a remote degree to the public health does not necessarily render the enactment valid. The act must have more direct relation as a means to an end, and the end itself must be appropriate and legitimate before an act can be held to be valid, which interferes with general right of an individual to be free in his person and his power to contract in relationship to his own labor. So the ideal may be shared in advocacy. How do you see? Perhaps not in advocacy. Actually, the court would operate in principle of neutrality. So the jargons or structures from the statute as to be in consonance with a technicality, what is a so actually the issue in some aspect could be disposed in practical consideration of element, and often technicality of a jurisprudence could permit some the space that conservative judge would patronize. So that, however, would work as one shield about many important public constitutional values. So we need to be carefully disposed about the opinion, code opinion, or what is actually formulative of the outcome, and how did the court reason on the unconstitutionality, or in other case, permissibility of the statute. The act in court opinion, within any fair meaning of the term, a health law, but is an illegal interference with the rights of individuals, both employers and employees, to make contracts regarding labor upon such terms as they may think best, or which they may agree upon with other parties to such contract. Statutes of the nature of that under review, limiting the hours in which grown and intelligent men may labor to earn their living, are mere meddlesome interferences with the rights of the individual, and they are not saved from condemnation by the claim that they are passed in the exercise of the police power and upon the subject of the health of the individual whose rights are interfered with, unless there be some fair ground, reasonable in and of itself, to say that there is material danger to the public health or to the health of the employees if the hours of labor are not curtailed. So actually, public officers, notwithstanding the judiciary or legislature, would often act on science and information. The litigation would incur lack of evidentiary documents, or an expert testimony would be afforded in any sufficiency to advocate one side or others. And the Congress also aided with experts and staffs. So this case could be what? Less in element about public health. So the goals of statute would be seen in that aspect, as you see, and it is impossible, according to court opinion, for us to shut our eyes to the fact that many of the laws of this chapter were passed under what is claimed to be the police power for the purpose of protecting the public health or welfare are in reality passed from other motives. So the corroboration and consistency with the goals and the tools to be employed. So we also have a dissenting opinion from Justice Hara, Justice White and Justice Day concurred, and also Justice Holmes dissenting. Let's have some words from Justice Hara. We judicially know that the question of the number of hours during which a workman should continuously labor has been for a long period and is yet a subject of serious consideration among civilized peoples and by those having special knowledge of the laws of health. Suppose the statute prohibited labor in bakery and confectionery establishments in excess of 18 hours each day. No one, I take it, could dispute the power of state to enact such a statute. The statute before us does not embrace extreme or exceptional cases. I've commented that this case could be highlighted in terms of a New Deal package. This case is decided upon an economic theory which a large part of the country does not entertain. If it were questioned whether I agreed with that theory, I should desire to study further and long before making up my mind. But I do not conceive that to me my duty, because I strongly believe that my agreement or disagreement has nothing to do with the right of majority to embody the opinions in law. It is settled by various decisions of this court. The state constitution and state laws may regulate life in many ways, which we as legislators might think as injudicious, or if you like, as tyrannical as this, which equally with this interfere with liberty to contract. Sunday laws and usury laws are ancient examples. One. A more modern one is the prohibition of lotteries. The liberty of citizen to do as he likes so long as he does not interfere with the liberty of others to do the same, which has been a shibboleth for some well-known writers, is interfered with by school laws, by the post office, by every state or municipal institution which takes his money for purposes so desirable, whether he likes it or not. So he illustrates Mr. Herbert Spencer's social statics. The 14th Amendment does not enact this. Let's see. The other day we sustained the Massachusetts vaccination law. Jacobson versus Massachusetts. 2 years ago, we upheld the prohibition of sales of stock on margins of future delivery in the Constitution of California. The decision sustaining an 8-hour law for minors is still recent. So, scope of a public intervention to be condemned in some classes and to be sustained by the court. In Lochner, the court gave private property interest priority over what a state legislature had defined as the public interest. The political and economic battle between these two sets of interests were at the core of the legal debate of regulation in the early 20th century and continue to play an important role in today's debates. This debate did not consider replacing private property with state-owned industry, as in socialist countries. So actually, you see the entrenchment of this structure through intellectual domain and also common law series. The code in Lochner also illustrated the National Labor Relations Board versus Jones Routine Steel Corporation, decided in 1937. In this case, the Supreme Court upheld the Wagner Act, which established the National Labor Relations Board. Chief Justice Hughes' opinion for a 5-member majority offers a legal solution to the political and economic debate over regulation, a solution that combines private property rights and public rights to protect the general health and welfare of society. So we also have important remarks from Carl Clay, who is a law professor, and he argues that the court's solution was to update legal consciousness and to make it more responsive to contemporary social exigencies. That is, to give a new life to the liberal legal order, while at the same time preserving its contradictions and mystification about the relationship between capitalism and democracy. And in the case titled National Labor Relations Board versus Jones and Lufkin Steel Corporation, the respondent argues, while contesting the ruling of the board, that the act is in reality a regulation of labor relations and not of interstate commerce. That the act can have no application to the respondent's relations with its production employees because they are not subject to regulation by the federal government. So you see the context of a dual sovereignty. In some cases, the federal government has no arms to regulate the private matters. State sovereignty is principled in structure. Of course, that would practically not the case in current form of virtually unitary concept of republic. That the provisions of the Act violate the second of Articles and the Fifth and Seventh Amendment of the Constitution of the United States. So you consider the necessary and proper clause, for example, how do you see, interstate commerce clause about interstate trade or transportation, what is. And in this case, the National Labor Relations Board found that the respondent, Jones Lufkin Steel Corporation, had violated the act by engaging in unfair labor practices affecting commerce. So the proceeding was instituted by the Beaver Valley Lodge number 200, affiliated with the Amalgamated Association of Iron, Steel, and Tin Workers of America, a labor organization. So the aggrieved party now raises a constitutional challenge against this act. So the Organic Act, which also includes a scope of duties and responsibility powers. So now, the argument from the respondent. The court would review in 5 points what the scope of act, and in second, the unfair labor practices in question, and what is it? The court also considered the application of the act to employees engaged in production and the principle involved. And the court also investigated effects of the unfair labor practice in respondents' enterprise. And finally, the court review the means which the act employs. So the purpose or goals have to be accepted, and the means which the act employs also has to corroborate in coherence in system, and should not be condemned in terms of a constitutional muster. So, what is the scope of that? The Act is challenged in its entirety as an attempt to regulate all industry, thus invading the reserved powers of states over their local concerns. We think it clear that the National Labor Relations Act may be construed so as to operate within the sphere of constitutional authority. The jurisdiction conferred upon the board and invoked in this instance is found in provision 10A, which provides section 10A. The board is empowered, as hereinafter provided, to prevent any person from engaging in any unfair labor practice affecting commerce. Actually, we see the unionism is a fair extent of commerce and national economy considered, and also the labor would combine to constitute the whole essences of national economy considered. And you see in the context, for example, Congressional Commission of Labor, what is? Actually, now the public intervention for a social justice is also involved in higher extent of practices, institutional or internal interplay as essential in some aspect. Of course, the judicial authority may be ultimate in many cases. However, as I said, difference and leniency to be engaged in other branches. And in the context, I like to introduce one important concept. You see what is iron triangle in this modern bureaucratic practice. So actually, a labor union is one interesting section which intersects with a capitalistic camp is considered. So their struggle may be framed and be seen in that highlight you consider. So the Congressional Commission and the departmental branches or units, or in some cases department itself, has maintains a close relationship to operate. The Constitutional Commission mission and all. It is a pivotal to structure the shaping of public policy, national context, and also one other player. What is that? Private enterprises or interested persons. So actually, the labor union or enterprises play lobbying and others. So it's a central place of contention and a debate, public debate, and most of important and essential policies could be produced in that interplay and process. So we call it a iron triangle. So consider in comparison with the role of judiciary about new agenda or public policies. Actually, the labor issues or unionism in the early of the last century, 20th century, is shared a great public focus. So this case actually diverges the context in any convivial way, I consider. We think it is there can be no question that the commerce thus contemplated by the Act is interstate and foreign commerce in the constitutional sense. The grant of authority to the board does not purport to extend to the relationship between all industrial employees and employers in terms do not impose collective bargaining upon all industry regardless of effects upon interstate or a foreign commerce. It purports to reach only one may be deemed to burden or obstruct the commerce and thus qualified. It must be construed as contemplating the exercise of control within constitutional bounds. Whether or not a particular action does affect commerce in such a close and intimate fashion as to be subject to federal control and as to lie within the authority conferred upon the board is left by the statute to be determined as individual cases arise. So the cause so is necessary to inquire whether in the instant case the constitutional boundary has been passed. Then, what is the second point? The unfair labor practices found by the board are those defined in Section 8, Subdivision 1 and 3. These provide, it shall be unfair labor practice for an employer to interfere with, restrain, or cause employees in the exercise of the rights guaranteed in Section 7 by discrimination in regard to hire or tenure of employment or any term or condition of employment to encourage or discourage membership in any labor organization. So actually, we now consider the section may be a foul of a constitutional bounds. So the structure differ in terms of a comparative, a constitutional perspective. From a Korean practice, you consider the labor rights now has long been dealt in a constitutional scheme, and you will find several provisions which is important to guide the respective branches. Of course, that would be prescriptive. How much legal effect could be ascertained would be another problem. So the financial resources and economic status of a nation would factor to circumscribe the adequate mandate of Constitution. It depends on many other non-legal factors or elements. Of course, the context, that nature of controversy now prevail. not only of a Korean authority, but also of global jurisdictions involving law and public policy. Section 7, employees shall have the right to self-organization, form, join, or assist labor organization, to bargain collectively through representatives of their own choosing, and to engage in concerted activities for the purpose of a collective bargaining or the mutual aid or protection. So, in this present application, according to the court reasoning, the statute goes no further than to safeguard the right of employees to self-organization and to select representatives of their own choosing for collective bargaining or other mutual protection without restraint or coercion by the employer. So that is a fundamental right. Employees have as clear a right to organize and select their representatives for lawful purposes as the respondent has to organize its business and select its own officers and agents. So discrimination and coercion to prevent the free exercise of right of employees to self-organization and representation is a proper subject for condemnation by a competent legislative authority. What is third point? Respondent says that whatever may be said of employees engaged in interstate commerce, the industrial relations and activities in the manufacturing department of respondents' enterprise are not subject to federal regulation. The argument rests upon the proposition that manufacturing in itself is not commerce. And what are fourth point? Effects of the unfair labor practice in respondents' enterprise. It is obvious they will be immediate and might be catastrophic. We are asked to shut our eyes to the plainest facts of our national life and to deal with the question of direct and indirect effects in an individual vacuum, because they may be but indirect and remote effects upon interstate commerce in connection with a host of local enterprises throughout the country. It does not follow that other industrial activities do not have such a close and intimate relation to interstate commerce as to make the presence of industrial strife a matter of the most urgent national concern. So, how do you consider the mandate of interstate commerce on labor relations? The code rather so the interstate commerce itself is a practical conception. So experience has abundantly demonstrated that the recognition of the right of employees to self-organization and to have representatives of their own choosing for the purpose of collective bargaining is often an essential condition of industrial peace. So refusal to confer and negotiate has often one of the most prolific causes of strife. And we see the fifth point, the means which the Act employs. Respondents assert its right to conduct its business in an orderly manner without being subjected to arbitrary restraints. What I have said points to the fallacy in the argument. Employees have the correlative right to organize for the purpose of securing the redress of grievances and to promote agreements with employers relating to rates of pay and conditions of work. The Act does not compel agreements between employers, and employees. It does not compel any agreement whatever. It does not prevent the employer from refusing to make a collective contract and hiring individuals on whatever terms the employer may be unilateral action determined. So the court finally reached the conclusion that the order of the board was within its competency, and the Act is valid as here applied. The case was gone contrary. Therefore, the Supreme Court struck down the judgment of the Circuit Court of Appeals, and the cause is remanded for further proceedings in conformity with the Supreme Court decision. So the case was considered as important in terms of jurisprudential philosophy. It can be said to end the tension between private property rights and the government's right to protect general health and welfare of society. We're now talking about the Jones versus Loring. And we also come to know a close reading of the opinions in Moon reveals an interesting legal wrinkle. What appeared to bother Justice Field in his dissent was that the ceilings on the charges grain elevators could exact from farmers through the mini monopoly of the business took the elevator operators' property from them without just compensation. So the question, therefore, is not just whether property could be taken from its owner for public goal. At least in theory, this power is undisputed. What is disputed, as in the case of Moon versus Illinois, is what counts as property and when a regulation can be classed as a taking of property. So the first prong about this case actually long discussed in philosophical circle, you consider. So the property concept often succumb to the public cause, public goal that could be embraced earlier by many scholars. Then our issue could be narrowed, involving the concept of property and the legal recognition about taking of property. So regulated takings and other concept you see later. Then how do we study the case titled Dolan versus City of a Tiger? The court in this case introduced important concept, essential nexus. What is the concept? It should be dealt between the legitimate state interest and the permit condition exacted by the city. So the public condemnation of land or property right should demonstrate this element, essential nexus. It is actually a prerequisite required of a permissible taking. And then we would consider other requirement, the degree of connection between the exactions and the projected impact of proposed development. In this case, the Dolan applied to expand a store and pave a parking lot upon compliance with the dedication of land. The state of Oregon, what is the name? TIGAD, is City Planning Commission, and also manage the dedication of land statute, public rules to be respected by project developers. For public greenway along Fauna Creek to minimize flooding that would be exacerbated by the increases in impervious traffic congestion in the city's central business district. So the city of TIGAD imposes a condition which, of course, restrict the use of land and abridged in against the interest of property right with the use of a land. What is second condition? The property owner has to develop a pedestrian bicycle pathway to relieve traffic congestion in the city's central business district. So Dolan could be denied his application since she includes variances from these standards to the land use board variances from these standards. So he actually dishonored the imposition of requirements, conditions, standards. So he appealed to the land use board of appeals. So this is the dispute involving administrative law, and we consider it an independent tribunal to adjudicate. And however, she seemed to be failed his appeal. So his allegation is that the land dedication requirements were not related to the proposed development and therefore constituted an uncompensated taking of property under the Fifth Amendment. So Luba, the independent tribunal, found a reasonable relationship between the development and the requirement to dedicate land for greenway, since the larger building and paved lot would increase the impervious surfaces and the runoff into the creek. And also the tribunal found the appeal could not stand, since the standard could serve alleviating the impact of increased day traffic from the development and facilitating the provision of pathway as an alternative means of transportation. So how do you see the projected development? The Oregon City like to ensure its pertinence and permissible relationships based on constitution and statute. The second part of issue requires us to determine what the degree of the exaction demanded by the city's permit conditions bear the required relationships to the projected impact of a petitioner's proposed development. Here, the Oregon Supreme Court differed to what it termed the city's unchallenged factual finding supporting the dedication conditions and found them to be reasonably related to the impact of the expansion of the petitioner's business. So actually, we often see the employment proposed developers. And in some cases, the proposed development may be filed from policy addresses, cities or enterprises. In this case, Dolan be involved with that proposed development. And the city required that a petitioner dedicate to the city as Greenway all portions of site that fall within the existing 10-year floodplain and all property 15 feet above boundary. So the city authority has extensive provisions about regulation and restriction. And the question is whether these findings are constitutionally sufficient to justify the conditions imposed by the city on petitioners' building permit. We think the reasonable relationship test adopted by majority of state court is closer to the federal constitutional norm than either of those previously discussed. So one common rule would be found, a reasonable relationship. And in close feature, we also see another rule, love proportionality. So now the leniency about state agencies could be practiced in extent. So actually the court would espouse the idea, concept, love proportionality. Love proportionality. It best encapsulates what we hold to be the requirement of the Fifth Amendment. No precise mathematical calculation is required, but the city must make some sort of individualized determination that the required dedication is related in nature and extent to the impact of the proposed development. So, can you interconnect this view with a intelligible principle, rule of intelligible principle? Sorry. The code will not require precise calculation, mathematical calculation, what else. However, that could not take account of all the circumstances. For example, in some requirement, the court imposed a reasonable calculation or some statistical evidence to support the rulemaking or justification to implement the policies. So if petitioners' proposed development has somehow encroached on existing greenway space in the city, it would have been reasonable to require petitioner to provide some alternative greenway space for the public, either on our property or elsewhere. The court saw it did not meet this requirement. And in next case, titled Callover City of New London, the court also considered similar nature of development plan. The trial judge and all the members of Supreme Court of Connecticut agreed that there was no evidence of an illicit purpose in this case. In a review of this case, it is important to turn on the question whether the city's development plan serves a public purpose. In this case, development plan was pursued by city authority. We also consider the common law rule. What is that? Naked attempt on the part of state of Hawaii to take the property of A and transfer it to B solely for B's private use and benefit. It is a very notable case decided in Ninth Circuit. Hawaii Housing Authority versus Midkiff, decided in 1948. In that same time, the Supreme Court decided another public use case that arose in purely economic context. The case name is Lucas versus Monsanto, decided in 1984. So the court also shaped an important concept, a reasonable certainty. What is that? Petitioners maintain that for takings of this kind, we should require a reasonable certainty that the expected public benefits will actually accrue. So the court would not be as strict to require a precise mathematical calculation. However, the court saw it elementary, and in order to satisfy the constitutional mandate, a reasonable certainty has to be respected. So condemnation or taking of a private property should not be arbitrary. The concept would work to what is sift and winnow for the legitimacy of a public policies. So came left to what? So behind the schedule class progress, we will get tightened about the rest of topic in next class, and I encourage you to record the materials uploaded in my personal webpage, and we will complete the 3 illustrations about a due process concept, due process of law concept, and the core rules to delineate, the code rules to delineate the essences of that requirement. Okay, that will be all for this class, and see you in the next class. Thank you for your attention.